Assalamualaikum. We are Group 8 and we will present our answer for the business law final assignment. Each of us will explain one part of the equations. Before we start, we would like to introduce ourselves first. My name is Cik Nur Imadina.
My name is Arina Marisa Khadija.
My name is Adam Afiful Ismail.
My name is Kasih Kemelia binti Nazra Zahai.
And I'll be presenting question 1A. When a company is incorporated, it becomes a separate legal entity from its owners and directors. This means the company itself owns property, enter contracts, and is responsible for debts in its own name. However, if the company is used for dishonest or improper purposes, the court may lift the corporate veil and hold the people behind it personally liable. Legal issue 1. Principle of separate legal entity. Section 20 of the Companies Act 2016 affirms that a company has the capacity of a body corporate upon incorporation. In Malaysia, the court have consistently applied this principle. For example, Lease Air Farming 1961 AC12 confirming that one person can be both because the company is separate. And if John and Maria form GM Enterprise, the shop will belong to the company, not them personally, and any dealings regarding the shop will be in the company's name. Legal issue 2, which is lifting the corporate veil. Despite separate legal personality, courts may pierce or lift the veil in case of fraud, scam, or misuse of the corporate form. Under Malaysian law, the court has the power to discard the separate legal entity when justice requires. For example, Hotel Jayapuri, National Union of Hotel, Bar and Restaurant Workers 1918, 1 MLJ 109. The court lifted the veil to identify the true employers of workers. Statutory provision also allow veil lifting. If JM Enterprise is created solely to avoid John's contractual obligation to Ahmad or to mispresent the sale, the court may lift the corporate veil and treat the transaction as John's personal act. This prevents misuse of incorporation to defeat creditors or obligation. In summary, incorporation gives a company its own separate legal identity, protecting John and Maria from personal liability. However, this protection is not absolute. If John used JM Enterprise to avoid selling the shop to Ahmad or mislead him, the court may lift the corporate veil and hold John personally accountable. Therefore, while separate legal entity is a shield, it cannot be abused to commit fraud or evade lawful obligation. That's all from me. Thank you.
And now I will be explaining about question 1 for B. So the question is, advise Ahmad on his likelihood of success if he still want to own John's shop. So firstly, I will start with introduction. So for the introduction, there's the two main law that connect with the question, which is the first one is the Section 2H of the Contract Act 1950, which is a contract is defined as an agreement enforceable by the law, and the second is Companies Act 2016, which is there's an issue of fraudulent conduct and the potential for lifting the corporate veil under the Company Act 2016. So basically, the first legal issue 1 was there a valid contract between John and Ahmad? Because we can see from the question, we can see that there's already an agreement, or you can say a contract made by John and Ahmad, which is John already agreed to sell his family shop to his close friend Ahmad. So, under Section 2H Contract Act 1950, a contract is an agreement enforceable by the law. So, based on the question, we can see that John already made a very clear offer to sell the shop, and Ahmad already accepted. So, that's already a binding contract. So, in conclusion, for the legal issue 1, there's already a valid contract between Ahmad and John. So, for the legal issue 2, can John revoke the offer after the acceptance? So, based on Section 5 to Contract Act 1950, revocation of an offer is only valid if communicated before acceptance. So, we can see that if Ahmad accept the offer before John revocation, because we can see that John want to revoke the contract because his wife, of course. So if Ahmad accept the offer before John revocation, the contract is binding. So in conclusion, if acceptance occur before revocation, John cannot withdraw the offer. Yeah. Next, for the legal issue 3, was the sale to JM Enterprise Sederhana Berhad a genuine transaction or a way to demolish Ahmad right? So if JM Enterprise was formed to solely defeat Ahmad a contractual right, the court may lift the corporate veil. Because based on the Section 20A Companies Act 2016, a company is a separate legal entity. However, the court may disregard this separation in case of fraud or evasion of legal obligation, because we can see from the question that his wife Maria insists that they form a company with only 2 of them as a director and sell the shop to a new company called JM Enterprise. So from the question we can see that they try to create the JM Enterprise was formed to avoid selling to Ahmad. So because of that, the court may lift the veil and enforce the original agreement. An example of case law is Jones v. Liebman 1962, land transfer to company to avoid specific performance. Court order transfer to original buyer. That is an example of case law. And for conclusion, Ahmad. So basically, in conclusion, the likelihood success of Ahmad the likelihood success of Ahmad if he still want to own John shop is there's a 3 situation, which is he accept John offer before it was revoked. So basically, Ahmad already accept the offer before John said that he want to revoke it. So basically, that's already a binding contract that already created. Next is there was clear intention and consideration. And the third one is JM Enterprise was formed to defeat his right. So basically, there is a wrong thing. Based on the Companies Act, it's a fraud, because the company was created only to defeat Ahmad contractual right. And yeah, lastly, the court may enforce the original agreement and order specific performance, especially if the sale to JM Enterprise was a sham. Ahmad should pursue legal action promptly to protect his interests. So I think that's all from me. Now I will pass to the next person. Thank you.
For today's presentation, I will be explaining question 2A. This question is about the validity of the contract between Azura, who is a well-known artist, and Zorifin, who is an art dealer. According to Section 10 of the Contract Act 1950, a contract is only valid if it is made with free consent, legal consideration, and legal purpose. If one of these elements is missing, then the contract will be not fully valid and it may be considered void or voidable. In this situation, Zorifin used a threat to make Azura sign the contract. He said, "If you don't sign, I will spread false rumors about your artwork." This is a problem because under Section 14 of the Contract Act, consent must be free. If a person agrees to something because pressure, threat, or fear, then the consent is not free. According to section 15, this is called coercion. Coercion means using threats or unlawful pressure to force someone into a contract. Here, Zul's words clearly pressure Bajra into signing the agreement. Because the contract was made under coercion, we must look at section 19 of the Contract Act 1950. This section says that a contract made under coercion is voidable at the option of the person whose consent was not free. This means the contract is not automatically void, but the effect party, which is Bajra, has the right to either continue with the contract or cancel. In this case, Bajra is free to cancel the contract because his decision to sign was not made voluntarily. This situation is similar to the case of Kasarma v. Varia Pachatia, 1954. In that case, the court decided that when someone signs a contract because of coercion, the contract is not fully valid and can be avoided. Therefore, just like that case, Bajra's contract with Zul can also be avoided because it was not signed with free consent. The conclusion that I can conclude about this case is the contract between Bajra and Zulkifli is voidable because it was signed under coercion. Zul used threat to force Bajra, and this makes the consent invalid under the Contract Act. Bajra has the right to cancel the contract and he is not legally bound to continue with it. Thank you. That is my explanation for question 2A about the validity of the contract.
So for my part, I will be analysing question 2B, which is about the impact of Zulkifli's trade and the issue of ownership and the enforceability of his agreement with Bajra. So in contract law, enforceability depends on whether the agreement is made with a free consent and whether the subject matter is valid. So for the legal issues and the explanations, so the first one is Zulkifli's threats. Under section 15 of the Contract Act 1950, coercion means committing or threatening to commit an act forbidden by the penal code to force a person into a contract. Zulkifli threatened to separate false rumors about Bajra's at work, which amounts to defamations and is an unlawful act. Because of this threat, Bajra's consent was not free. According to section 19 of the Contract Act 1950, any contract made under coercion is voidable at the option of the innocent party. And this means Bajra may rescind the agreement. So for the second one is the issue of ownership. So under section 7 of the Contract Act 1950, a valid sale requires that the seller owns or has the right to transfer the goods. So here, Zulkifli did not own the paintings and some were counterfeit. So this amounts to misrepresentations under section 18 or even fraud under section 17. So a relevant case is Tan Chi Chiu v. Aston Mining and Metals Co. Ltd, which confirms that contracts based on misrepresentation can be set aside. Therefore, agreement cannot be legally. So the agreement cannot be legally enforced. So in conclusion, Zulkifli's trades amount the coercion making the contract voidable under section 19 of the Contract Act 1950. His lack of ownership and counterfeit works amount to misrepresentation and fraud, which render the contract unenforceable. And Bajra therefore has the right to rescind the agreement and not legally bound by it. So thank you.